The Evangelical Fellowship of Canada and Christian Higher Education Canada represent a number of Christian post-secondary institutions, including Trinity Western University, most of which have similar codes of conduct. And so my comments today are coming from that perspective and with that perspective in mind. And what I'd like to do in the short time I have this morning is address some of the questions, perhaps some is ambitious, address one or two questions that came from the court yesterday and this morning. And I'll start with a question Justice Rowe asked yesterday, which was in some ways reiterated this morning, which was, would it have been illegal for the law societies to accredit Trinity Western? That was also one of the submissions made by both the law societies. And in trying to address that, I'm also going to try and address the exchange you just had with Mr. Ross about, would it have been different if it was actuaries, or as Mr. Staley mentioned yesterday, are lawyers special? My submission on that is no, we're not special. And no, it would not have been illegal for them to accredit Trinity Western. Nothing Trinity Western does is unlawful. The community covenant is not unlawful, and this court confirmed that in 2001. Trinity Western isn't bound by the charter. None of the Christian universities that I'm speaking for here today are bound by the charter. And if anybody brought a charter challenge to strike the community covenant or portions of it on the grounds that it violated the charter, they wouldn't succeed. Similarly, Trinity Western isn't bound by the Ontario Human Rights Code, and it doesn't violate the BC Human Rights Code, because both of those human rights codes carve out exceptions and provide protections to Trinity Western and similar religious organizations. In my factum, I point to a recent decision from the Ontario Human Rights Tribunal. You'll find that reference at paragraph 35. You don't need to turn to it. But that decision dealt with a complaint by a same-sex couple whose child was refused admission to a private Christian school. And the tribunal rejected the complaint because the Ontario Human Rights Code protects that kind of an organization associating building walls and determining who they are and defining their character. And I say it's no different here. There is nothing unlawful about Trinity Western or the community covenant or similar community covenants or codes of conduct. Now, to try to address the question that came up again this morning, are lawyers special? I don't think we are. And I think this court would agree with that. If we look back at our jurisprudence, in '96, this court decided both Ross and Odette, and both of those cases dealt with teachers. And both of those cases recognized the important role teachers play in forming children and in civil society in general. 5 years later, it decided Trinity Western, which dealt with the accreditation of a teacher's college. So we would have to suggest that lawyers, who generally would deal with adults who already have shaped their beliefs, play a more important role than teachers who help form and shape those beliefs. And I
don't think anybody's arguing, and I'm glad you didn't mention judges as not being but there is a difference between, arguably, having a profession which requires you to uphold the law and implement the law on behalf of clients, well, and other organizations, isn't there? So it's not a hierarchy of special professionalism, it's a question of difference in mandate of the different professions.
There's no doubt about that, but as I understand it, and I don't want to delve into the facts of the two cases, but as I understand it, there's no allegation or evidence to suggest that Trinity Western or their graduates would not uphold the law.
Should be forced.
Right. But let me try and say a few words on why I don't think this argument about accrediting would be endorsing or promoting. By that logic, this court endorsed Trinity Western's moral views on marriage in 2001. By that logic, this Human Rights Tribunal in July endorsed the moral views of this Christian Christian elementary school. And I guess the Minister of Education in Ontario does as well by allowing that school to operate. It's just not how the charter works. You're not violating the charter by tolerating people exercising their charter rights. If that was the case, it would be completely incoherent, and certain charter provisions would be mutually exclusive of each other. And I'll end on this analogy to again address this issue of accreditation or licensing or tolerance being approval or endorsement. In 2004, this court dealt with the same-sex marriage reference, and in that decision was very clear that although the charter protects the right of same-sex couples to be married, nothing would compel or could compel religious officials to officiate those marriages. And nothing could compel houses of worship to host those weddings. And the language used in that decision is very strong. Freedom of religion is broad and jealously guarded. Well, officiating marriages is a public function. So is the government endorsing or approving the religious views of a priest or a rabbi or an imam by allowing that person to officiate marriages? I say no.
Thank you very much.